Good morning, and thank you everyone for joining us for this employment law update and HR horrors with Cilla Robinson and Lauren Cooper from King Wood Mallesons. We're recording the session, so if you need to catch up later or share it with colleagues, we'll get the link out ASAP. I would like to start by acknowledging the traditional custodians of the various lands on which we work today and pay respect to elders past, present and emerging, and extend that respect to First Nations people joining us today. So a brief introduction from me. I'm Angela Franks, the partner for Fraser Jones here in Australia. Fraser Jones is a global HR recruitment and search business operating across the whole spectrum of HR. It's been an interesting 12 to 18 months in the HR and recruitment space. So if you're thinking of a move for yourself or hiring for your team and want to understand more about the trends or need someone to partner with, please do get in touch. For anyone that's been tuning into these webinars for a little while, you know that Cilla's updates that we have twice a year are always very insightful, and her knowledge in this space is exceptional. Outside of this, we're also planning a variety of other online and face-to-face events this year with a particular focus on AI, but more in a workshop kind of format. So if anyone does have any specific issues or topics in AI and how that relates to HR, please pop me a note either on email or LinkedIn, as I'd love to hear from you so that we can shape those events. There's been a lot around AI in the broader sense, but we really want to try and do some more sort of niche topics to help people. But I'll pass over to Cilla in a sec, but we're always delighted to partner with you, Cilla, and thank you so much for joining us again. Cilla is the partner at King Wood Mallesons and has over 24 years experience in employment law. We're also joined by Lauren today, who's a senior associate working in Cilla's team, which covers workplace relations, employment and safety. So Cilla is going to cover key updates in the employment law space, including DEI, psychiatric injury, psychological safety and psychosocial risks. So I'll hand over now. Sorry, I've got a bit of a cold, excuse the sniffing. Cilla will be presenting and I'll be looking at the Q&A. I'll be monitoring that. It does go a bit crazy, so I'll try and get to as many questions as possible. But you're all on mute and videos are off during the session, so we can record it and we'll get the link out ASAP. Over to you, Cilla.
Thanks so much, Angela. It's great to be back at HR Horrors. So I've got Lauren with me here to do the heavy lifting, standard partner approach. And as Ange mentioned, in terms of the agenda, we're going to be covering DEI, psychosocial hazards, a case update as well, the Alicia Vision case, which you may have already heard about. But look, jumping straight in, I'm conscious we want to have time for questions. The first topic is, has DEI really died? And in terms of the death of DEI, there's been a number of different things that have occurred in terms of the geopolitical environment that have really impacted on where we are today. So I just thought it was helpful to cover some of those key factors that have occurred in the US that have led us to the current position where we're seeing organisations around the world starting to wind back DEI. The important thing to mention is that the backlash to DEI isn't new. As many of you would know as HR practitioners, there's actually been a backlash to DEI really for the last 20 years since we've had discrimination laws. But in recent times, we've seen a real focus on this anti-woke agenda. And in particular, after the Me Too movement, post the Harvey Weinstein scandal, and the Black Lives Matter movement post George Floyd's death in America, there was real momentum to this anti-DEI agenda. And the key criticism from those who are on board with that agenda is that these DEI policies undercut merit as a driver for success in the workforce. So that's the counterpoint to the views that we'll certainly be espousing today. But in terms of the factual background, in 2023, there was a handful of cases involving universities in America, in particular Harvard and North Carolina University. And they were discrimination cases brought by Asian American students that were asserting that programs, affirmative action programs in America designed to get Latino and Black students, they were found by those cases to be unlawful. And specifically, they were found to have breached the Civil Rights Act and the American Constitution. Now, these decisions overturned 45 years of precedent in America. So it was a big deal. And as a result of these cases in the tertiary sector, what we saw was white men bringing claims in the context of corporate programs to support gender or cultural diversity or LGBTIQ plus workers. They were bringing claims to say that these were discriminatory. And as a result of that case law change, American companies started looking at their DEI policies, concerned that they were going to create legal exposure for them. Then, of course, we saw Trump come into power and issue the executive orders that I'm sure you've all heard about, which eliminated government DEI programs and basically made DEI programs unlawful for the purposes of companies who were contracting with the American government. And importantly, it wasn't just an executive order that had no teeth. The executive order gave powers to the general counsel and executive leaders and the attorney general's department to actually enforce this new position that basically, made DEI programs akin to, corruption or money laundering and the like. So this naturally created a significant shift where American companies were really having to wind back DEI, in particular where they contracted with the American government. So we saw some really big names. Walmart was the first, which was quite significant because they rolled back a 5-year commitment to racial equity, which they established after George Floyd's death in 2020. We then saw McDonald's. Meta announced a few days later that they were changing and disbanding their DEI programs, and Mark Zuckerberg famously talked about bringing back masculine energy. Amazon went next. And then we saw a number of different organizations in America winding back DEI. Now, of course, many of the organizations on this screen have companies in Australia as well. And from a professional services perspective, Accenture changing their programs and abandoning targets was quite a significant one because the big four accounting firms and Accenture are some of the few organisations in Australia that actually had targets for both gender and cultural diversity. But moving on to the landscape in Australia and our very strong position that there is absolutely no need for Australian companies to follow the American lead. And the main reason for that is that we have a very different legislative framework in Australia that allows positive discrimination. It allows affirmative action programs so that those cases that I spoke about simply couldn't be brought here without the organisation having a sound defence. But it is important to note that there is still a backlash in Australia. A few months ago, we saw Rio Tinto report that all of the great work that they had been doing post the Respect at Work report had resulted in this backlash and resistance to DEI that many of us who work in this space are very familiar with. So there is a backlash in Australia, and many people were very happy about this anti-woke agenda, thinking finally we're going to be getting some power back to the people that are primarily in positions of power, which historically and continue to be white men. And white men can absolutely be allies. This isn't me hating on white men, but just pointing out that they are not a minority group. So the first reason why we're different is that we have special measures provisions in our discrimination laws, which allow affirmative action programs. And Lauren's going to talk about that shortly, so I won't unpack that with you. But then we also have the positive duty under the Sex Discrimination Act. And most of you, if not all of you, would be acutely aware that as a result of the Respect at Work reforms, we now have a positive duty to eliminate, as far as possible, sex discrimination, sexual harassment, sex-based harassment, conduct that creates a workplace that is hostile on the grounds of sex, and also related acts of victimisation. So DEI initiatives often overlap with positive duty obligations. So it's difficult to see how an organisation can be discharging the positive duty that it has under the Sex Discrimination Act by entirely abandoning its DEI initiatives. Now, Queensland has gone further in terms of the positive duty, or did go further, subject to a pause, which Lauren will discuss at the back end of the session. But we have, as importantly, positive duties at both state and federal levels. And then, of course, we have WGEA reporting, which I'm sure you're familiar with, but Lauren will unpack in a moment. Over to you, Lauren.
Thanks, Cilla. So as you'll all be aware, at the federal level, we've got the 4 discrimination acts that are obviously in place to protect and prevent discrimination on the basis of race, sex, disability, and age. And each of these acts contains a special measure provision which allows for affirmative action, as Cilla mentioned, so that it can be lawfully implemented for realising substantive equality for the relevant groups. So depending on the circumstances, these provisions can be used as a defence against a legal challenge to an organisation's DEI program. So I'll use the Sex Discrimination Act today as an example. So under the Sex Discrimination Act, as you can see on this slide, there are special measures that can be taken for the purpose of achieving substantive equality for those listed on the slide. For example, between men and women, between people of different sexual orientations or gender identities. And in addition to this, employers can also apply for a temporary exemption, for instance, to run targeted recruitment or specialised training programs. And this level obviously requires some detailed legal analysis between what might be a special measure or what might actually require a certain exemption to be made. I'll turn now to the special measures, and the Australian Human Rights Commission actually has some guidance under the measures in the SDA and how they're intended to operate, which gives a nice practical framework for the HR to be conscious of and aware of in the programs that we run and you've got in your organisations, no doubt. So these steps obviously will minimise the risk of complaints that are the risk of complaints that as such measures are discriminatory, and will provide a basis to dispute such a claim, obviously, if the claim is made. So it's also good practice for the individuals and the organisations to clearly identify the relevant documents about the decision to take special measures, and then obviously that legal basis is well documented. The first step here is to identify the specific inequality that the organisation is targeting. So that could be considering the examples on the previous slide, for example, underrepresented women in the workforce. You also need to have a think about inequality and whether that's supported by evidence. So organisations are looking at the statistics and data available to them to identify this in the first step. So then the second step is thinking about how the proposed special measures will achieve the substantive equality. So this is the thinking about the why. You selected the particular measure so that they can address the specific inequality being targeted. The third step is considering whether the proposed special measures are proportionate and appropriately targeted. Now, this is an important one, having regard to how the legal drafting of this clause is in this, the Sex Discrimination Act, and how courts will consider those measures. So that it's important that they don't go beyond what is necessary to achieve the substantive equality of that identified area. The fourth step is then considering how you'll monitor the effectiveness of the measure. So it's advisable that the special measure ceases once that equality has been achieved, or the target that you had identified that you set out to achieve has been met, because then it may no longer be considered a reasonable or a special measure. So that is why we require that periodic review. And the fifth step obviously goes without saying, that we'll need to link that special measure back to the DEI program that's in place within the organisation. So looking at that framework, it sets it out quite nicely and clearly for when organisations are looking at these requirements. And I'll come back to the WGEA reporting shortly and some new targets that are coming into place, which makes that even more relevant. So that was the federal level. I'll turn quickly to the state special measure provisions. We obviously wanted to highlight that most of the states and territories, with the exception of New South Wales, as you can see on this slide, also contain a general special measure provision within their anti-discrimination legislation. So while New South Wales doesn't have that general special measure provision like the other acts could have or do have, it does include exceptions in favour of positive discrimination in some limited circumstances. So that just highlights the importance of having a closer look at the relevant legislation and also seeking advice when it's necessary. So where a measure or an action is a special measure, as I mentioned before, it will not constitute unlawful discrimination. And that's because it already falls within a recognised exception to the discrimination law. So whether the special measure provision actually will apply and whether the application for an exemption request might be required in each of the states and territories is often highly fact and situation specific. So we really encourage your organisations and the people that you work with in your teams to consider and seek advice from internal counsel or external counsel when you are considering either renewing or implementing or any changes to the existing programs, just to ensure compliance with the laws. I'll turn now to the reporting requirements, which you're no doubt all aware of because they've been in place for some time. The objective of the law obviously for WGEA is to promote and improve gender equality and to promote the elimination of discrimination on gender and employment. And it does this through public disclosure of gender pay outcomes. So in the most recent reporting results, it showed that at least 72% of employers still have a gender pay gap that is in favour of men. And on this slide, you can see here that the average is also adding up to a yearly difference of just over $28,000, which is not insignificant. There's a good news story in that 56% of employers have reduced their gap, but then on the other hand, 44% of the employers have increased their gap. So yeah, as you can see that there's still a bit of work to go in this area. I'll just briefly touch on the indicators and the gender equality indicators that organisations with 100 people are required to report on. And that's really just on this slide, so I'll go quickly. Gender composition of the workforce and the governing bodies, equal remuneration, the availability and utility of employment terms. So that includes things like flexible work arrangements. The consultation with employees is a key one, including on matters relating to gender equality. And then the last one here, 6, is sexual harassment is harassment on the ground of sex. So that was introduced as well to report on the measures that are implemented within organisations or larger organisations to report on what they're doing in that space and what policies they may have in place. So the scheme includes standards that the employers must meet in relation to those indicators, and it uses this possibility by trial of media to encourage improvement in relation to gender equality. And WGEA has the ability to publicly name employers for non-compliance in accordance with the Act. So if an employer fails to meet the indicators or the standards in a year, and then it fails to improve in the consecutive year, there's an ability for them to publicly name the employer and detail its non-compliance in a report. So that possibility of the public backlash because of the the poor gender pay gap, I should say, motivates employers to take that gendered remuneration issue seriously. And that's obviously a basis for you to be having these discussions with your organisations and within the teams and the projects that you support to make sure that this is an issue that's taken seriously, because there is an increasing amount of media attention that's given to this issue predominantly affecting Australian women, including sexual harassment, which is obviously becoming a popular topic in the media. So that was the existing obligations. Under the new obligations, and there was an act that was passed just last month through Parliament, which is currently awaiting royal assent, is to introduce some new obligations on organisations with more than 500 employees. And that will be a requirement to commit to and to achieve at least a few targets that are selected by an organisation. So interestingly, that will be to improve on the gender equality targets in relation to their DEI. So you can see how this links back into what Cilla was saying earlier in the investigation, in our presentation, around what will be required under these new laws when they're finally implemented. So that's a bit of a watch this space in terms of what those requirements will be to select certain targets and then to report on them on a 3-year basis. So I'll hand back over to Cilla.
Thanks, Lauren. So hopefully you're now clear that our legislative framework is different, and that would actually be quite dangerous for organisations to wind back DEI entirely, as has been contemplated. But in good news, many organisations in Australia have come out, ASX listed and others, to say that they are going to continue their support for DEI. We've got a handful of majors on the screen, but there've been many more that have come out to support their DEI programs. And interestingly, we have seen some divergence of American-based organisations in Australia, namely McDonald's and Meta, have expressly said that they will continue to support DEI, but what that looks like specifically remains to be seen. So in terms of what happens next, we aren't immune to the DEI debate. The backlash is absolutely here. It is not going away. But as we've mentioned, our legal framework is different, so that rolling back DEI programs to the extent that they are in America is going to be quite problematic in terms of organisations continuing to comply with Australian laws. Even if DEI continues to be embraced by organisations, I think for HR professionals, it is important to acknowledge that DEI now is like a dirty word. It's it's tainted essentially. So what we are seeing is that in order to try and confront this anti-woke, anti-DEI agenda, we are seeing organisations starting to talk about human rights rather than DEI. And yes, it's just a change in semantics, but it is much harder for somebody to argue against the concept of, well, do you believe that all employees should have the same rights at work? Do you believe that all employees should have equality and equal access to opportunities, etc.? So positioning DEI as actually a human right equal to everybody might go some way to address some of those concerns about merit not being the basis of decisions in terms of organisations. And look, I think in terms of your organisations, the economic benefits of diversity, equity, inclusion are clear. The research demonstrates that diverse thinking, increases productivity, it increases returns on investment and the like. So none of that has changed. The resistance will be there. We've got laws that require you to stay the course. But I think one thing that I did want to emphasise is that because of the geopolitical situation, many minority groups, including women, are feeling under threat. People can see their rights being eroded in America. There's been, observations that are we going to go back to Handmaid's Tale type scenarios with reproductive rights being under attack in America. So I think just acknowledging that many people aren't feeling safe, that has an impact on people's psychological safety at work, which of course is something that your organisations need to be thinking about. So just bear that in mind when you are reflecting on what, if anything, you're going to change in terms of DEI programs. And the only other thing I wanted to say about this is that the merit argument that has been put forward by this anti-woke agenda assumes that there is a level playing field. The reality is that there isn't a level playing field. Bias, discrimination, all of these things impact on people from diverse backgrounds, and I include women in that group in terms of minority groups, don't necessarily have the same options as men. So it's important just to acknowledge that this merit argument is a bit of a fallacy, because it does assume that everybody is starting at the same baseline, which unfortunately we aren't. So that's DEI. What we're going to move on now to is a really interesting case, Alicia and Vision, and then, as we said, we'll end on psychosocial safety. So in terms of this case, you may have heard a little bit about it, so I won't go into the background in a huge amount of detail, but loosely, Mr. Alicia was employed by Vision Australia in 2006. He had an existing condition of anxiety and depression with heightened sensitivity to particular sounds, chronic workplace stress, and interpersonal difficulties with some members of staff. So that was a pre-existing condition that he had. In March 2015, he stayed at a hotel while he was travelling for work. He heard noise. He complained about that noise. He changed rooms. As a result of all of that, a complaint was made by the hotel manager to his employer. Mr. Alicia went on leave, came back from leave, was stood down, was then asked to attend a disciplinary meeting 2 days later. He provided a written response to allegations against him relating to this incident at the hotel, and was ultimately terminated because the employer accepted the account of the hotel manager rather than Mr. Elisha. Now, following the termination of his employment, Mr. Elisha was diagnosed with a major depressive disorder and adjustment disorder with depressed mood, and he was found to have no capacity for work in the foreseeable future. So quite a significant impact on him, his earning capacity. He brought an unfair dismissal case in the Fair Work Commission. It was settled for the maximum compensation, which is 6 months' pay, as many of you would be aware. Deed signed, deal done, vision assumed, that's all good. Mr. Elisha is in our past. 5 years later, in 2020, he commences proceedings in the Supreme Court of Victoria seeking to recover damages for the psychiatric injury he suffered on account of the manner in which the termination occurred. So the Supreme Court of Victoria found that the hotel incident hadn't occurred in the manner that had been asserted by the hotel manager. It found that the employer had relied on reasons for the termination that Mr. Elisha, hadn't had an opportunity to respond to, so some procedural defects in that regard. And ultimately the termination was found to be a sham and a disgrace, unfair, unjust, and wholly unreasonable. Now, importantly, it was found that the termination process had contributed significantly to Mr. Elisha's psychiatric injury, and the court found that it was a serious possibility, if not likely or on the cards, that he would have suffered that injury, i.e. the employer should have been alive to that risk in its handling of him. And he was awarded $1,442,404 in that decision. So what are the primary issues that were considered by the court? The first one is the contract. This issue of, can an employee claim damages for a psychiatric injury if the employer breaches the disciplinary procedures in place before the termination? Secondly, this negligence issue, does an employer breach a duty of care if it doesn't take reasonable steps to prevent an injury of the employee during the termination process? And appreciate that's probably a whole lot of legalese for you all as HR professionals, but there are some really significant aspects to the judgment which are relevant to you. So the first one was that the disciplinary procedure was contractually binding. Now, you'd all be aware that policies don't have the effect of being contractual in nature unless they are incorporated to an employment contract. So what we had here was that the court found that his contract meant that the policies and procedures of the organisation had a contractual force, and of course they bound both the employer and the employee. Vision asserted that it only applied in that sense to the employee, and that notion was rejected. Importantly, this decision actually, has overcome the previous case or precedent on this, which is called Addison Gramophone, which found basically that you couldn't get damages for a psychiatric injury arising out of the manner of termination rather than an event that occurred during the employment. So it's a significant change that really heightens the risk, in particular for employment lawyers like us and HR professionals like yourself. So the key takeaway is you can get damages for a psychiatric injury that has arisen as a result of the termination. These were previously not recoverable. Secondly, the incorporation of the disciplinary procedures was crucial to the relief that was granted to him. And importantly, employers can be liable for psychiatric injuries that arise from the incorporation of company policies. So in terms of what you need to do because of this case, some recommendations for you. The first one is review your contracts of employment to check that you don't have an incorporation of company policies. And many companies still do have these clauses, even though it's been out of favour for decades now. So check your contracts to check that. If you have a incorporation issue, or even if you don't have an incorporation issue, ensure that you are actually complying with your own policies in terms of the manner in which you undertake performance and termination issues. So again, complying with your own policies is generally best practice. If you have these policies incorporated into contract, it is a must-have. And of course, prioritize employee well-being in terms of the process, have regard to how the employee is feeling in the termination process. Again, this is HR 101. And finally, and this is less your world and more our world, but review your release agreements to ensure that you don't have an issue like we had in this case. So in terms of the employment contracts, I'm not going to go into this in any detail, but we've included this slide in the deck so you can have a look at it later. We've got side by side the drafting of Mr. Alicia's contract and our recommended drafting to avoid this incorporation of policy issues so that you won't have a contractual obligation to comply with policies. As I mentioned, disciplinary policies and procedures are important. The real thing for you to all just remember is that a serious departure by an employer from its own policy is more likely to mean that an employer is liable for a psychiatric injury that an employee suffers as a result of the termination process. And then finally, the release document. I mentioned that they paid him 6 months' pay, the maximum compensation he could get for an unfair dismissal. He brought this claim. Why on earth could that happen when there was a deed of release in place? Well, the answer is that the deed of release was poorly drafted. And in this case, it was found that the deed of release, because of the word "and" being used in terms of the release relating to the employment, the proceedings, and the termination, it meant that all of those things had to be together. And so the release was really relating to the termination proceedings and not the process of the termination. So it's a technical legal argument, but it is just a reminder to reflect on the language of your deeds of release to ensure that you won't have an issue whether an employee can come back and have a second bite of a cherry. Had this deed not had this defect in it, he wouldn't have been able to bring that second claim. So that leads us to our final topic of psychosocial hazards and risks. Quick reminder, there's model employment laws that have been adopted around the country in all states other than Victoria. Victoria has its own similar laws. Obligations exist at the organisational level. We refer to that as a PCBU, a person conducting a business or undertaking. Health, of course, includes physical health and psychological health, and duties are at multiple different levels. So you've got the organisation, the PCBU, you've got directors' duties, and then you've also got duties for all employees. And breaches of health and safety are obviously a big deal. Safety regulators are all over both physical and psychological safety, and penalties can include jail time and millions of dollars. This next slide is really just included in the pack, again, as a reference for yourselves to understand the difference between a psychosocial hazard and a psychosocial risk. What we want you to focus on in your day job is minimising the impact of psychosocial hazards. And the next slide has a whole lot of examples of psychosocial hazards. Again, something for you to look at later. Importantly, we're not just talking about bullying, harassment, all of those obvious psychosocial hazards, role overload control, how the work is done. All of these things are psychosocial hazards, and increasingly we are seeing claims being brought on the basis of, micromanagement, surveillance and things like that, rather than traditional psychosocial risks being those obvious forms of trauma that employees experience. So in terms of psychosocial trends, I just wanted to reinforce that we feel like we're more sophisticated these days in terms of mental health and well-being in the workplace. Are you okay day? We have breakfast, we have mental health first aiders. But what we've actually seen is post-pandemic, there has been a decline in psychological safety. And the stats demonstrate that this has a real impact in terms of productivity and performance, costing billions of dollars to the Australian economy in terms of the impact of poor mental health. So just a reminder that, during pandemic times, employees felt very supported from this perspective. Post-pandemic, back to work, requirements, cost cutting, restructures, all of these things that the increasing cost of living has had is decreasing psychological safety. So just a real reminder that your employees are feeling significantly less safe at work than they were literally during lockdown, during the COVID pandemic. But I'll hand over now to Lauren to talk briefly about the Queensland WHS amendments that I flagged earlier on.
Thanks, Cilla. So as you can see on this slide, we've obviously set out for your refer to later some of the recent amendments in the safety space in Queensland. And we apologise if you've listened to one of these webinars in recent times, because obviously this is one of the really important changes in this space that's been spoken about quite a lot. Importantly, on this slide is that requirement there on the 1st of March, just last month, for organisations in Queensland to have a written prevention plan. And I'll come back to the requirements of this shortly. The other thing to note on this slide is, as of just last month, the Queensland government actually paused the introduction of the anti-discrimination laws that were set to be implemented later, mid this year, that would have introduced a broader positive duty for other types of protected attributes. So that's actually now on pause because they'll be undertaking some further consultation. So that's just the other amendment to be aware of in recent times. So turning to the written prevention plan, as I mentioned earlier, this includes requirements for the plan to be in writing, to state the identified risks, and the regulations actually set out quite a lot of detail around what things are relevant to consider in this regard, the relevant control measures that are to be implemented for each of the risks. Importantly, then you also need to document the consultation that's been undertaken in developing the plan, and also the process for dealing with reports, which is now much more sophisticated than we normally would have seen in grievance procedures before. So this document, the safety teams within your organisations should be quite across. However, if this is something that's new to you or you haven't had any input into that document, we encourage you to have those discussions, because the best clients that we see, or the best organisations that get this right, have a team where there's input sought from multiple stakeholders within the organisation. So that's from a safety perspective, but also from a HR perspective, but then talking to managers and workers so that they understand where the risks are, what control measures might actually work. And the organisation then considers that feedback that's been provided in assessing what can be done and documenting it in this plan for execution. So I also just wanted to note on this prevention plan is that it will also be mandatory in Victorian workplaces soon under the proposed psychosocial health regulations. So the Victorian government expects that those regulations will be finalised in October later this year and take effect from the 1st of December. So it's a bit of a watch this space. What we know now is that employers should expect to be required also to have written prevention plans for certain psychosocial hazards, including relating to aggression, violence, bullying, exposure to traumatic content or events, high job demands, and sexual harassment. So that's a watch this space. The other part of the Queensland regs and also safety best practice is an ongoing review mechanism within your current processes. So the regs actually require that you review and revise the control measures when someone reports sexual harassment or sex or gender-based harassment at work. The important part there is what the trigger is. So whether there's somewhere in our systems or in the processes or the back-end documents that you've got that you follow when we're dealing with reports being made, is to take a step back at the end of that investigation or grievance handling procedure to understand if there are things that we need to be doing, and then also clearly documenting that that step has been taken. For the HR people in the room, I think, and we encourage people to be asking yourselves these kinds of questions, such as, are the control measures working effectively without creating new risks? Have all of the psychosocial hazards been identified? Have psychosocial hazards or risks changed, or are they different to what was previously assessed? So that sparks that review and changes to the control plan or the prevention plan that we spoke about earlier. So are new control measures available that might be better used to control the risks, or have the risks been eliminated or minimized as far as reasonably practicable? So as you can see, all of these these stop points at the end of a trigger or a report being made helps to enhance our compliance with the legislation that's required in Queensland. But a lot of our national practice organisations are actually applying this across the board on a national level. So just as a bit of a recap, here are some high-level steps in this space which organisations are taking. Obviously, having a written prevention plan, which is a requirement in Queensland from March last month, and soon to be Victoria. But as I said, many organisations with the national presence are adopting this as a best practice and having a national approach because that is really the highest watermark and the level that's required out of the regulators at this time. So complying with that will ensure compliance across the board with some slight deviations, I should say, in each of the other states and territories subject to the codes and other materials that the regulators do push out. Obviously, providing training for HR and safety to be across the psychosocial hazard requirements, undertaking the psychosocial hazard identification risk assessments, consulting with the workers, and this is one of the greatest risks we see working with organisations, is that we've done the risk assessments, we've got the plans, or we think we have the controls, but we may not have consulted to the required level with our workers, and I'll come back to this shortly as well. And then mapping the current measures against the regulatory obligations and considering the risk control. So that's also on a state basis, and also having regard to what your organisation does. Obviously, the risks in some workplaces, such as IT, is going to be very different to, say, a mining site or somewhere else with more strict regulatory requirements. So having regard to your organisation against each of the regulatory obligations is crucial. And then updating the current incident reporting processes and other procedures. So having regard to what the requirements are, what frameworks you've got in place currently, and what gaps there might be so that you can address those within the organisations. This is where we see the most work going on at the moment. So I thought I'd just briefly recap on the risk management process, and I wanted to hone in for you on the identification of hazards. So this is obviously a process in terms of identifying the hazards, assessing the risks, the control measures, and an ongoing review requirement that the safety teams or your safety personnel will be very familiar with. However, I think in organisations we all have a part to play in terms of identifying the hazards and flagging those up so that everyone's protected and we can ensure a safe workplace and safe work systems. So on that, what I can say is that we understand in New South Wales in particular, there's been legislation that was just passed establishing Safe Work New South Wales as a standalone statutory regulator. Most of the state and territory regulators have increased resources and capability in their investigation and enforcement arms in light of the nuances and dissociation with, nuances associated with the investigation of psychosocial hazards. So we do expect regulator activity in this space to increase. So coming back to the identification of hazards, as you can see, it's really important that we are taking that broader range approach and understanding, and everyone having a role to play in that process to ensure that then the rest of it is flowed on via the relevant channels and flagging it up to managers and the safety team so that they can be addressed. So it's things like consulting with the workers. If you're having conversations and you become aware of risks that people are raising with you, flag them down, make sure that they are passed on to the relevant team. If you're made aware of them, it's the same as the organisation being made aware of them. So it's important that we take that step further. Workers might not use the terms that we typically expect to see in that space, and the buzzwords would include things like stress or burnout, being emotionally exhausted, being anxious or scared. So it's being conscious of those discussions and flagging things up. The worker surveys are a really great tool to understand and gather information. They're often also done on an anonymous basis, which means that people come forward with issues that they might not otherwise raise. Understanding the confidence levels of workers raising issues, if they have seen it or if they did see it, is a good lag and lead indicator to assess ongoing compliance and to assess that on an ongoing basis in future surveys to understand whether your systems and reporting mechanisms are working and if people feel safe to speak up. Having a survey that's available to everyone is important so that you actually get representative views of all workers within the workplace, and that's really important. The one that people see most often is observing workplace behaviour. So how people interact with one another is often a good telltale sign of whether there's any issues that might exist at that level. And obviously, it goes without saying, reviewing the data available. So that's looking at your lag and lead indicators now to try and figure out, records of injuries, workers' compensation claims, grievance registers, workplace investigations or safety reports, records of hours worked and the type of work that people are doing, manager issues or complaints, things like absenteeism and turnover. So these are all useful data that your organisations will definitely have and are probably part of an ongoing review of where these hazards exist and what risks might be associated with those hazards so that they can be addressed in this framework. So on that note, I will pass back over to Cilla.
Cilla, you're on mute. I was on mute as well.
There's always one. There's always one.
Yeah.
Look, this last slide is just a plug for a resource that was released yesterday by us and the Australian Institute of Company Directors. Lauren and I and a couple of our colleagues at the firm have been working on this since before Christmas, and it really is a document which talks to the foundations of psychological safety. It's geared towards directors, but it really does unpack some of the basics in a really nice way. So to the extent that this whole world of psychological safety is a challenge for you, then I recommend that you take a look at that. We've also done a two-part think piece on diversity, equity, inclusion, which unpacks some of the things that we've spoken about today. And so we've got links to both of those things in the slide pack, which Ange will share to you all at the later today. So look, I think we wanted to make sure we always go over time and we end up, going into people's lunch break. So we wanted to ensure that we had some time for questions. I'm happy to see that we've got 10 minutes within the actual hour that has been dedicated. And I had a squeeze in the chat while Lauren was talking. So I might just start answering the questions that were in the chat. Whilst we then, see whether there's any other questions that are coming out. So there was a reference to universities being impacted by the Trump anti-woke agenda. Absolutely right. It happened in America first. Any universities that had DEI programs had their funding cut from Trump. Now it's unfortunately flowing to Aussie universities that do receive quite a lot of funding from the US government. There will be funding terms. It will be university specific as to whether that's going to be found to be lawful. But I think the outtake for the tertiary sector that we do quite a lot of work with at King Wood Mallesons is that there will have to be a decreasing reliance on America for funding in the same way that his executive orders that slashed American aid means that the rest of the world is also going to have to be less reliant on the US in terms of aid, whether it's food for Africa or developing countries and the like. So a pretty sad state of affairs. Unfortunately, that is the reality. There was a question about, where is it? There was a question about the WGEA reporting. Have the targets been launched yet? No. The targets are for the reporting period of 2025 to 26. So they're going to be reporting in between April and May 2026. So that's just some information so that you can get ahead of the curve. Let me see. There was another question about WGEA. What are the consequences if you don't report? And look, the consequences are really naming and shaming. You get publicly named that you haven't complied with those obligations. And look, query whether that's significant. The consequence, though, of being named and shamed is can be quite significant depending on the organisation. So that can result in, for example, losing government contracts, being ineligible for grants, Commonwealth grants and like, and of course the obvious one that the name and shame is geared towards, which is reputational damage. So you don't get stung with, a massive dollar penalty, you don't get sent to jail, but there's no world where it has no impact on you, given organisations that are required to report, are big enough to have, contracts with a range of parties that will turn their minds to these things. And the other impact is that prospective employees quite often look to this as a data point of what their organisation that they might be considering moving to is like. So I think it also impacts on both attraction and retention of staff. There was a comment about people feeling, is it a concern, to have regard to well-being during a performance process? Everybody's feeling bad in that process. Absolutely right. No employee enjoys going through termination process, performance or conduct management. But as HR professionals, you need to still have regard to their well-being, because you need to execute the process, but you still have this work health and safety obligation that applies to all workers. So it's really about the manner in which it's done. If the process is heavy-handed, if the person hasn't been afforded procedural fairness, these are going to be problems. But what we're not saying is, if a person cries because they've got a warning because they've done something, stupid or terrible, that you can't proceed with the process. In this case, we were talking about a pre-existing disorder that was then significantly exacerbated by the termination process, such that the guy, in Alicia's case, could never work again. So it's an extreme example. Lauren, I don't know if can you see the questions? Probably not. You could probably stop sharing the screen if you wanted to, Lauren, but let me have a look. There's a question,
Yeah.
Will the deck be shared? Yes, it will.
Yeah. There was one above that from Jerome, going back to the DEI. Can you see that
Oh,
one?
yeah.
It's a long one, so I won't read it all out. Oh, and there was one other one from Alex about the target above 500 employees, best practice for less. Did you cover that?
I haven't covered that, yes. I mean, I think the answer is yes, absolutely best practice. 500 is the big size of the organisation that WGEA requires reporting for, but absolutely in the same way that people voluntarily report for modern slavery just as a best practice thing to do, to be able to say that they do it, absolutely it's a great thing to do as a smaller organisation where you're picking goals and in particular have a good news story to sell. Now, let me read this question from Jerome.
On your question before, Cilla, around the process for performance improvement plans and termination processes, absolutely. That there's obviously considerations around well-being and safety throughout that process, increasingly so from a workers' comp and a personal injury perspective, because obviously you follow the right procedural fairness steps when someone is award covered or where there's obligations in policies to do that. But increasingly, the view is that we should also afford employees who might not have those protections in the awards or in their policies, the same protections from a well-being and a safety perspective to reduce liability on other sorts of claims that can arise. So that's also just something to keep in mind.
Yeah, look, so Jerome's question is talking to being a person of colour in a number of different organisations at Sydney, and his concern that DEI strategies might be wound back, and who's the right person to be pushing DEI initiatives. Look, I think the reality is, and there's been a lot written about white fragility, Jerome. Aussies are, we're in a multicultural country. Most Aussies don't think that they're racist. Many Aussies aren't racist, but still might be acting in a way that is not sensitive to their colleagues of colour, their non-English speaking colleagues. And so people, sometimes act in a way that's not respectful, and often react quite badly to race in particular. It's a particularly vexed topic in Australia, which, outside of the Eastern Seaboard and the coast, there still is a very big portion of racist Australia, unfortunately. So I think I would suggest you need to confront the issues head on, have very bold and courageous conversations, but expect a lot of pushback because, the cultural diversity piece is, I think, the most challenging aspect of diversity management, because it's not a one-size-fits-all approach. And there is a lot of resistance. The iteration of discrimination harassment training has moved to anti-racism training, which can be quite confronting for people when you start unpacking exactly the sorts of behaviours that people engage in all the time that are making their colleagues feel unwelcome and or discriminated against. So there's no obvious answers to that other than to continue to have the bold discussions and to also be pushing within your organisation to look at these things. But reality is a lot of discrimination DEI practitioners are white, and there's nothing wrong with that. But I think it just means that sometimes you need to work with them as allies so that they can understand your lived experience. Oh my goodness, is there anything else? Have we missed anything? In the Alicia case, was the pre-existing condition declared at hiring? It was known. It was a pre-existing condition. It wouldn't have made a difference because the termination process impacted on it. So it wasn't the final injury was actually caused by the termination, but there was a pre-existing injury. Whether it is hard. Sometimes you might suspect somebody has a disorder and a mental health illness. You need to have regard to that. If you're not on notice about it, then there can't be an expectation that you were aware of it. But generally speaking, we start getting some of these cues, and the fact that someone hasn't disclosed it openly wouldn't have impacted on this case in a significant way. But in his case, they were actually aware of the anxiety and depression that he was suffering. So that's why the court found that they should have expected that would have worsened to the degree that it did when he wasn't treated fairly in the termination process. That's it. And have we got
you've
two other
done it.
questions?
Oh my word.
Wow.
I think we've done it with 1 minute spare.
1 minute to spare.
I know.
There you go.
That's
must be Lauren. It's all Lauren.
I'm loving it.
I'll take the
take the credit. It's you.
Take the credit. Well, look, thank you so much, Cilla and Lauren, for a wonderful session. We always manage to cram so much into the hour, so I really appreciate your expert knowledge and sharing that with us. Yes, I think we put it in the chat, but we will be sending out a link to the recording and sending out the slide deck. Once Cilla gets that over to me, I'll get that out. But yeah, I hope it's been useful for everyone. Please do reach out to Cilla or Lauren if your organisation needs any help with any of these issues, and enjoy the rest of your day wherever you may be. Everyone's saying thanks,
everyone.
Yeah, in the chat.
Thanks, everyone.
See
Bye.
See you later. Thanks for joining. Bye.
Bye.